4. Concerning fraud, we know the objection often directed against the rule that has just been formulated. To determine the nationality of the corporation by a fact that depends directly and immediately on the will of the founders is to render fraud not only possible, but very easy. The organizers not having been able to avoid by an express stipulation the legal provisions normally applicable, will it suffice them for attaining this object to take an indirect way as short and as plain? Desirous of avoiding the severe provisions to which the French law has subjected the Constitution, the function and the dissolution of corporations or national associations, to escape the taxes imposed in Italy on Italian corporations, they decide that the meetings of shareholders and the Council of Administration shall assemble in Switzerland or in Belgium, for directing from there a corporation which pursues its activity in Italy or in France, country which serves for residence of the technical director and delegated administrator. This combination is foiled by the system which allows the judges to fix the social nationality according to their impression, without indicating to them any particular criterion, or rather by that which prescribes to them the fixing of it according to the seat of exploitation. The social nationality results, then, from the nature of things, and not from fancy or calculation. To refute this objection, it is observed that fraud vitiates all that it inspires, and that if the social domicile has been fraudulently established, which the interested parties will prove by all means, the judge will take no account of it. The refutation is a little summary. It supposes a point cleared up which in reality is very obscure. What is fraud and what are its conditions? The word fraud is ambiguous, for it designates every effort either to deceive someone, or violate the competent law. In this last sense, that which it means here, it implies two conditions: non-observance of the competent law, knowledge of this non-observance. What then is the competent law? It is the question to solve in each case, since the determination of the essential element of fraud depends on it by definition. It will often be difficult to answer it. Almost always, indeed, this question is put on the occasion of the concurrence of two legislations, that to which the accomplishment of such a fact, of such a formality, is capable of submitting the condition, the capacity of such person or the validity of such an act, that which would rule the condition, the capacity or the act of which it concerns itself if the first legislation were to be avoided. In what cases, in what measure does this cease to be applicable? This is the problem proposed. Some of the cases apropos to which these notions are practically realized will permit the measuring of its complexity. An Italian becomes a naturalized Frenchman. The only motive for this naturalization is to obtain a divorce that the Italian law does not admit. Will the French tribunals receive his petition? Ought they to reject it on account of the fraudulent character of the naturalization? If yes, what will be in Italy the effect of this change of nationality? A person transfers his domicile into a foreign country with no other intention than to withdraw himself from the jurisdiction of a court which would have had to decide an imminent process. Two French persons wish to marry abroad with the exclusive object of saving themselves the long formalities, costly and complicated, imposed in like case by the Napoleonic Code, for example, not to make the respectful announcements. The character common to these different cases is the well-established will among the parties of withdrawing a contemplated act from the provisions of the law which ought to rule it by the accomplishment of a fact, by a displacement or change of condition. These persons realize thus artificially the situation in view of which the rule of international law has been established, of whose benefit, for a special and momentary interest, they desire to take advantage of, either the rule locus regit actum, or that in virtue of which changes of nationality produce changes of conditions, etc. Different authors who can be cited among the masters of private international law forcibly maintain that such combinations are perfectly permissive. Fraud is the violation of the competent law. Now, the lex domestica cannot be thus qualified from which the parties have withdrawn themselves by the accomplishment of a fact or a formality authorized by this lex. Fraud would exist only if they had simulated this fact in a way of substituting an appearance in the place of the reality. For example, in feigning to transfer into another country the center of their interests for creating a belief in a change of domicile. We must guard against confounding these two situations. Having really done what he ought to do for that, the interested party is legitimately right in invoking the benefit of the law conformably to which he has acted without anyone opposing to him a law which is not applicable. Why could not this former Italian, naturalized Frenchman, conformably to the provision of his preceding national law which authorizes expatriation, use even in Italy a right which is conferred on him by his new personal statute, because he has been naturalized with a view of exercising this right? But naturalization is always inspired by the perspective of the material or moral advantages, it matters but little which, that result from acquiring a new nationality. This acquisition, once realized, ought to produce all of its consequences. The same reasoning can serve to prove the legitimacy of a change of domicile. Finally, no one can be said to shun a legal rule who avoids the fact in view of which this rule has been imposed. and thus render its application impossible. The same end. Here the expression of consent in the contract, can often be attained by different ways, one of which causes less trouble and expense than the other. If for this reason we leave this and follow that, we do not avoid the application of the law, we render this application impossible. To this reasoning can be opposed plausible arguments that jurisprudence has often inspired, if it has not always expressed. Without undertaking a regular refutation, which does not concern us, let us observe that the question is precisely to know if the law from which the naturalized one, the contracting party, or the eventual defendant have wished to withdraw themselves authorizes their attempt. If not, it can be said that it is really a maneuver designed to violate the competent law, and the definition of fraud is thus realized. When the French law recognizes, for example, the validity of a marriage of two French people in Spain according to local form, it considers the normal hypothesis, that where French people, removed from their country by the effect of circumstances occasioned by another cause than the sole will of removing themselves from the French law, they are interested in marrying on the spot, thus saving themselves the costs and troubles that a displacement would impose on them. Likewise it can be said that the Italian law, in allowing their citizens to be denationalized, validates those only of the consequences of this act which are not contrary to its prohibitions. But, I repeat, these considerations are not relative to our subject, and I must limit myself to putting clearly the problem by showing the solution of which it is capable. Returning, then, to the particular point of our interest, I shall have no difficulty in establishing that the notion of fraud, whose definition I have given and drawn some deductions for indicating its bearing, is not applicable to our case, but is realized only in case of simulation of the social domicile. We have, indeed, previously arrived at this conclusion, which it is important not to lose sight of, that the nationality of a corporation is determined in principle by its social domicile. It matters but little in which country it exercises materially its activity. No more account ought to be taken of the nationality of the members or of the origin of the capital, but the corporation is bound logically, naturally to the sovereignty of the territory where it has its principal establishment. This admitted, fraud is possible only in one case, when a pretended social domicile has been fictitiously established in a place other than that where it is really found, with a view of attributing to the corporation a certain nationality. This simulation is, indeed, a maneuver arranged to defraud the competent law, that of the country in which the corporation has in reality its domicile. This maneuver will be foiled by the determination of the real domicile and of the nationality which is the consequence of it. What if the seat of this domicile has been chosen in a country by the organizers for attributing to the corporation such a nationality? I ask, in what is this intention fraudulent? I ask that someone show me the competent law that has been violated or the sovereignty disregarded which was normally designed for governing this corporation. Yet again, there is not here, as in the cases which have just been enumerated, two sovereignties, two legislations in presence, one to which belongs the interested party, the other to which he has wished to submit himself. There is only a single one, the sovereignty, the legislation, of the country upon whose territory the social seat is fixed. To say that the competent law, that the competent sovereignty, have been violated or disregarded is nonsensical, since there exists no other than those whose competency is contested under the pretext of a pretended fraud irrealizable and even inconceivable. Considering, says in this sense the Tribunal of the Seine, that the nationality of a corporation determining itself by the place where it veritably and effectively has its social seat, it is of little consequence that the Atmospheric Nitrogen Company is composed in greater part of French stockholders and that it has for object the circulation of a process of French origin in a manufactory that ought to be situated in France. It is inadmissible, one will say, that the nationality of an artificial being depends, even indirectly, on the will of its organizers, for they cannot do indirectly what they are not allowed to do directly. Their will, and consequently all the facts which depend on it, ought to be without influence upon the social nationality. For avoiding this objection, let it suffice to recall what has been before presented, that the autonomy of the parties in no wise exercises itself in the same conditions in international law as in internal law, that besides the operation upon a territory of the organs of the administration, of deliberation, of control, depends not all on the pure and simple arbitrariness of the organizers or of the members. Let us observe finally that this argument is only a reproduction of the sophism that I have already refuted under its preceding form. In declaring fraudulent the pretended Belgian and English nationality of a corporation which has no other relation with England or Belgium than the situation of a domicile upon their territory, one admits a priori the existence of a sovereignty, that of the centre of exploitation, to which the contemplated corporation normally belongs, which its organizers seek fraudulently to bind to a foreign sovereignty in fixing its domicile upon the territory of this sovereignty. It is stated in principle that the state within whose jurisdiction this establishment is found is the natural state from which the corporation could not be withdrawn, it is deduced that the jurisdiction of this state can no more be laid aside indirectly by the accomplishment of a formality than directly, and that consequently the attribution of a nationality by the fixing of the social domicile in a country is fraudulent. Now, this is exactly the question. It cannot too often be repeated, there are not two laws, two sovereignties in presence, as in the application of the rule locus regit actum, but a single one, that under the empire of which the corporation is born and operates. Little consequence the reasons which have moved the organizers of this corporation to place it in this judicial domain rather than in another may be that of the state where is the principal center of exploitation. It is not that to seek them, and it would be vain to maintain that the members were interested from many points of view that the company should be French rather than Belgian, interest that has yielded to the desire of withdrawing themselves from troublesome restrictions. From the moment that the circumstance which logically binds the company to Belgium has been realized, this company is Belgian. Every other consideration ought to be laid aside under the penalty of falling again into the theory which, without adopting any fixed rule, is referred to the arbitrariness of the judge. This leads me to point out a notion of fraud different from that which I have defined, and which seriously limits the system I have adopted. We accept this system. The advocates of this new opinion say, we admit that the nationality of the corporation is that of the country where its social domicile is fixed, that is to say, the administrative seat, but, granting this, we refuse to go so far as to recognize in the organizers an absolute liberty in the choice of the place designated to serve as the seat of this domicile. Their choice ought to be influenced by serious reasons, arising from the interests of the new corporation, of its members, and of its subscribers. If the prudent management of the social capital, the object of the corporation, the territory where it will principally accomplish it, the nature of operations in view of which it is organized, the nationality, or the domicile of the subscribers or of their members reasonably influences the fixing of the social seat in a certain country, the establishment of this seat in another country with which the corporation is united by no lien will be dealt with as fraudulent, it being proved at least that the organizers have made this decision with the sole intention of applying a legislation whose liberal provisions they appreciate. The judges will then have to seek, on one hand, what was the interest well understood of the corporation and its assigns, on the other hand, perhaps if the organizers have wished deliberately to withdraw their corporation from the law and the sovereignty which might reasonably have governed them. One is obliged, says M. Theller, developing the system presented above, to give to the subscribers, when the contract of subscription is made in France, the guarantee of the observation of the French law upon the corporations, and it is in the territorial resort of this same law that should be found if not the only seat, at least a social seat. Every combination which would cause shares to be subscribed in France and would place the social seat in Belgium or London, in a way to float the enterprise according to an English statute or the Belgian law of 1873, to the exclusion of our own law of July 24, 1867, constitutes a judicial heresy, one of whose terms destroys the other by inflicting on it a contradiction. It would be wrong to think, writes an author on his side, advocate of the determination of the nationality by the administrative seat, that the place of the social seat is a geographical point freely abandoned at the choice of the organizers, and that we fall again into the inconvenience which we desired to avoid in rejecting the criterion drawn from the country where the act constitutive has been drawn up. It does not then belong to the organizer to place the seat of the corporation where he pleases. There is fraud not only when the administration is regarded as sitting abroad and sits in France, but even if the fact of sitting in France is a lie to the statutes. What can be thought of this conception of fraud? It offers at first sight something satisfactory. We shall see further on if the idea which it gives can be utilized after having been completed by its combination with that of the autonomy of the will. Applied here to a case where the determining fact of nationality clearly appears as well as the will of the organizers not to withdraw themselves from it, its practical conclusion, which removes them both, appears purely arbitrary. It is easy to recognize, slightly modified and restricted. The elective theory which I have previously criticized, in the terms of which the nationality of the corporation does not depend on a certain criterion, but on a combination of all the facts proper to attach it to a state. Those who thus restrict the application of the criterion drawn from the social domicile and confide to the judge the labor of seeking if this domicile, although real and effective, is not fraudulent, that is to say, contrary to I know not what numerous and divergent interests, necessarily indefinable and subjective because their determination is unconditional, since they compel him, the case happening, to fix the domicile of the corporation where it ought rationally to be in view of declaring it Belgian, French, or English, reach practically the same result as if they trusted themselves purely and simply to the impression of this judge for determining the nationality of the corporation. We know already that this result is as irrational as impractical. Under this first absolute form the theory I have just refuted has not, as is seen, much solidity. Limited to a special and well-defined interest, that which presumes the nationality or the domicile of the subscribers or the members, it presents itself on the contrary with a great appearance of probability. When the nationality of the subscribers is known, the country with which the corporation has the most serious liens is known, and to suppose that no other circumstance can furnish contrary indications, information is given concerning the domicile and consequently concerning the nationality of the corporation itself. If a corporation composed of French people places its seat in England, although the exploitation must be carried on in France, it is easily presumed that the members have used an artifice in choosing a territory which is neither that of their country nor that where they propose to work. Are they, on the contrary, English? The fixing of the social seat is easily conceived and one recognizes in the company the title that the organizers gave it. What M. Shavagran says of the nationality of the subscribers, one of the speakers at the Congress of Companies in 1900 applies to their domicile, a fact more easy to verify. This theory is not completely confounded with that of M. Thaler which I have just presented, indeed, without imposing on the organizers the strict obligation of fixing the social domicile in the country where the subscription has been made, at least in those to which the subscribers belong, it leaves them the alternative of establishing this domicile either in one of these countries or in that where the operations which are the object of the corporation are pursued, but nowhere else, under penalty of being convicted of fraud. If it is a question of a personal corporation it would be fitting to seek what has been the nationality of the members who have signed the act constitutive. In order to lay it aside, we limit ourselves to a simple remark. We have already virtually rejected the restriction to which it pretends to submit the bearing of the fact which we have adopted as criterion. If corporations take the nationality of the country where they live and act, where the center of their affairs is, from whence issues the impulsion and the direction, where deliberations are made and decisions are prepared, where control is exercised, it is that they belong judicially to the state in whose domain their personality is thus manifested. Of little importance, once more, the motives which have been able to determine among the organizers the adoption of this seat, of little importance even the natural relation which seems to unite a certain one of these corporations to a certain other state, the consideration of the domicile ought to prevail over any other one, at least. We shall see it when this essential element is not neutralized by the will of the members combined with a most accidental element and manifested at the moment of the organization. To oblige the parties to fix the social domicile in the place of issuance, or at the center of operations, is simply to make the social nationality depend on one of these two circumstances to the exclusion of that which we have adopted. It is to return by a detour to the system of M. Lincoln or to that of M. Thaler which I have refuted. We hold, then, to this definition of fraud alone applicable to our subject, the establishment of a fictitious domicile in a country other than that where the principal establishment of the corporation is effectually found, made with a view of attributing to this corporation a false nationality.